Case summary. The case of Suisse Atlantique Société d'Armement Maritime S.A.V. N.V. Rotterdam Centrale 1967 1 AC 361 was heard by the House of Lords in 1967. It is a leading case on the principles of liquidated damages and penalty clauses within contract law. Background facts. Claimant, plaintiff. Suisse Atlantique Société d'Armement Maritime S.A., a Swiss shipping company. Defendant, N.V. Rotterdam Centrale, a Dutch coal company. The claimant owned a ship that was chartered by the defendant under a charter party agreement for 2 years. The agreement stipulated that the ship would be used to carry coal from the United States to Europe. However, due to significant delays and inefficiencies caused by the defendant in loading and unloading the coal, the claimant experienced considerable financial loss. Argument. Claimant's argument. The claimant argued that the delays constituted a breach of the charter party agreement and sought damages for the losses incurred. They claimed that the sum of money specified in the contract for delays should be enforceable as liquidated damages. Defendant's argument. The defendant contended that the clause specifying damages for delays should be considered a penalty and thus unenforceable. They argued that the sum stipulated was disproportionate to the actual loss suffered and therefore should not be enforced. Final outcome and law justification. Final outcome. The House of Lords ruled in favor of the defendant, holding that the sum stipulated in the contract for delays was a penalty clause and not enforceable as liquidated damages. Legal justification. 1. Penalty clauses versus liquidated damages. The distinction between penalty clauses and liquidated damages is a key aspect of contract law. Liquidated damages are pre-estimated damages agreed upon at the time of contract formation, intended to compensate the non-breaching party for anticipated losses. Penalty clauses, however, are designed to punish the breaching party and are typically unenforceable. 2. Assessment of the cause. The court found that the cause in question did not represent a genuine pre-estimate of loss but was intended to exert pressure on the defendant to perform its obligations under the contract. As such, it was deemed a penalty. 3. Application of legal principles. The House of Lords reaffirmed the established principles set out in previous cases, such as Dunlop Pneumatic Tire Solid v. New Garage and Motor Solidi, 1915, AC 79, where the criteria for distinguishing between a penalty and liquidated damages were outlined. They emphasized the need to examine the intention behind the cause and whether it was a genuine attempt to estimate loss or a deterrent against breach. Key concept. Implication of the Suisse Atlantique case. 1. The case underscores the importance of correctly drafting clauses related to damages in contracts. 2. It reinforces the principle that penalty clauses are unenforceable, whereas genuine pre-estimates of loss, liquidated damages, are enforceable. Key takeaways. 1. When drafting contracts, ensure that any clauses specifying damages for breach are genuine pre-estimates of loss rather than punitive measures. 2. Understand the legal distinctions between liquidated damages and penalty clauses to avoid unenforceability. 3. The case demonstrates the judiciary's commitment to upholding fairness in contract enforcement, preventing the imposition of punitive damages under the guise of liquidated damages. This case serves as a vital precedent for both legal professionals and parties involved in contractual agreements, highlighting the critical nature of precise and fair drafting in contractual terms.